Good afternoon, everyone. I am Lily Franklin. I am the Administrative Program Specialist here at the Louisiana Department of Education Child Nutrition Program. Today, we will be discussing civil rights in the child nutrition programs. The purpose of civil rights training is to inform, educate, and support all staff that interact with child nutrition programs. This training will cover USDA civil rights requirements, staff responsibilities, and resources and information available to assist staff in carrying out the civil rights responsibilities. First, we will discuss public notification systems. This is the process by which sponsors notify potential applicants of the availability of meals. Second, we will discuss civil rights issues related to customer service practice. This could occur anywhere in the continuum of participation, from applicants turning in a free and reduced price application to overt identification of meal status in the lunch line. Third, we will cover the requirement to collect race and ethnicity data and why that information is collected. Fourth, we will briefly touch on issues of accommodating children with special dietary needs. This is not a complete special dietary needs presentation, but we'll cover the topic from the lens of ensuring equal access. Fifth, what should a sponsor do if they receive a complaint alleging discrimination in the summer feeding programs from a child or parent? Next, we will discuss what a sponsor should do if there are areas of non-compliance and how to handle reporting of compliance issues. And finally, we will discuss language assistance requirements. There are a number of civil rights laws pertinent to child nutrition programs. Title VI, Civil Rights Act of 1964, prohibits discrimination based on race, color, or national origin. Title IX of Education Amendments of 1972 prohibits discrimination based on sex under any education program or activity that is receiving federal financial assistance. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination based on disability. Additional civil rights laws include Americans with Disabilities Act of 1990, which prohibits discrimination based on disability in all services, programs, and activities provided to the public by state and local governments, except public transportation services. Americans with Disability Act of 2008, Age Discrimination Act of 1975 prohibits discrimination based on age in programs or activities receiving federal financial assistance. Civil Rights Restoration Act of 1987 prohibits discrimination based on race, color, and national origin. Here are other resources and authorities on civil rights in child nutrition programs. I will draw your attention to FNS Instruction 113-1, which is entitled Civil Rights Compliance and Enforcement, Nutrition Programs and Activities. This guidance covers the scope of civil rights laws in child nutrition programs. On January 20th, 2021, President Biden issued the latest executive order, which states that all persons are entitled to dignity, respect, and equal treatment under the law, no matter their gender identity or sexual orientation. Discrimination is defined as different treatment, which makes a distinction of one person or group, either intentionally, by neglect, or by actions or lack of actions, based on the protected classes. Examples of discrimination include giving one group or type of participants larger or extra helpings of food, separating genders, failing to provide children with a dietary disability, accommodating meals, failing to provide program information to all potential program applicants. Protected classes in the child nutrition program are race, age, color, sex, which includes gender identity and sexual orientation, national origin, and disability. Civil rights training is required annually for all staff. This includes full-time staff, part-time staff, temporary staff, central office staff, site staff, and volunteers. Documentation for civil rights training must be maintained for 3 years plus the current year. Documentation must include sign-in sheets, agendas, and dates and times of training. All civil rights trainings should be tracked on a training tracker tool. Civil rights training subject matter must include the following: collection and use of data, effective public notification systems, compliant procedures, compliance review techniques, resolution of noncompliance, requirements for accommodation of persons with disabilities, requirements for language assistance, conflict resolution, and customer service. All FNS assistance programs must include a public notification system. The purpose of the public notification is to inform applicants, participants, and potentially eligible individuals of the program availability, program rights and responsibilities, the policy of non-discrimination, and the procedure for filing a complaint. Through public outreach, sponsors are trying to ensure program access to as many potential participants as possible. Public notification must include information regarding eligibility, benefits and services, program availability, which includes the hours and locations, applicant rights and responsibilities, procedures for filing a complaint, non-discrimination policies, and any program changes. Sponsors must notify the public annually of their participation in the program. Notification to applicants and participants must include information regarding program availability, program rights and responsibilities, the procedure for filing a complaint, and the policy of non-discrimination. The public notification system must include the following elements: public release. Sponsors must take specific actions to inform the public of their program rights and responsibilities, as well as the steps necessary for participation in the program. Display the And Justice for All poster. Sponsors must display the And Justice for All poster in the correct size, 11 by 17, in a prominent location where it is visible to all participants in the program. The poster provides the USDA address and phone numbers that the public can use to file a complaint if they think their civil rights have been violated. Applicants and participants must be advised of their rights to file a discrimination complaint, how to file a complaint, and the complaint procedures. The non-discrimination statement. All informational materials, including websites used by sponsors to inform the public about FNS programs, must contain the non-discrimination statement. Public notification can include methods such as internet and computer-based applications, newspaper, radio/television, letters, leaflets, brochures, and bulletins. Be sure to convey the message of equal opportunity in photos and other graphics that are used to promote program information to applicants or participants. The media release must be provided near the beginning of the school year to local news media, the unemployment office, and to any major employers contemplating layoffs in the area. The media release must include the eligibility criteria for free and reduced meal prices. It is at the discretion of the media if they decide to publish the media. Another method of public notification is informational letters that inform households of program availability. Informational letters must be distributed by sponsors at the beginning of the program by mail, email, or in person. All sponsors must prominently display the And Justice for All USDA non-discrimination poster. The poster must be 11 by 17 in size. Posters should be displayed in each site in a location that is easily visible to students and the public in the food service area. The USDA non-discrimination statement must be included on all forms of communication and program materials. Program materials include all public information and education. The long version of the non-discrimination statement is required on all documents pertaining to student eligibility, such as prototypes of letters to the households, verification, and direct certification. The long version of the non-discrimination should also be used whenever possible or where space permits. The short version of the non-discrimination statement can be used if the document is too small and there is limited space, such as on menus or nutrition flyers. If using the short version of the non-discrimination statement, a 9-point font is required. Displayed is the long version of the non-discrimination statement. Okay. And displayed here is the long version of the non-discrimination statement in Spanish. Additional languages are available at fns.usda.gov. There are a couple of requirements when printing the non-discrimination statement. The first printing requirement is that the wording for either statement cannot be changed. The second printing requirement is that the print size cannot be smaller than the text of the material. Also note that in auditory presentations, such as public service announcements, the shortened version may also be used, but the long version is required on any vital documents, even if it is only 1 page long. The non-discrimination statement is required on any materials that mention the programs to the public. These materials may include advertisements, publications, letters, enrollment forms, broadcasts, sponsored websites, etc. Items that do not require the non-discrimination statement to be printed are incentive items, such as cups, buttons, magnets, pens, etc., due to the impractical size. Customer service is defined as effectively communicating with customers, responding to the customer's needs, valuing the customer's worth, and instilling excellence through courteous confidence and enthusiasm. Treating customers with respect and dignity through excellent customer service saves you time and minimizes opportunities for complaints and angry customers. Students must be allowed equal opportunities to participate in the child nutrition programs, regardless of race, color, national origin, sex, age, or disability. All participants of the child nutrition program must be treated equitably. In order to reduce the risk of a civil rights discrimination complaint, ask yourself the following questions each time a participant comes to your program for services. Number one, am I treating this person in the same manner I treat others? Number two, have I given this person the opportunity to ask questions? Number three, have I provided the person with the information he or she needs to make necessary decisions? During meal service, all students within the same grade grouping must be offered the same menu selection, regardless of their eligibility, sex, national origin, race, color, age, or disability. All varieties and selections must be made available to all students within the same grade grouping. In the examples provided, it would be discrimination to provide high school football players with bigger scoops of food or save certain food items for a specific group. USDA policy prohibits the denial of meals as a disciplinary action against any student who is enrolled in a site that participates in the child nutrition program. It also prohibits requiring a child to work for or earn their meals. Identifying information must not be used for any purpose other than determining and verifying eligibility for free or reduced meals. Overt identification should be considered in different situations beyond the application process. This includes at the point of service where other students may see eligibility statuses on the cashier computer screen. Or, for example, when special functions take place that require alternate meal service, such as field trips and class parties. In these instances, no overt identification of meal status should occur. Most conflicts are easily resolved by using appropriate tools. Conflict resolution consists of useful skills to assist with the solution of complaints. These skills include using a win-win approach, change the conflict from an attack and defense to cooperation, and avoid the desire to blame. Use a creative response. Turn problems into possibilities to improve the situation. Demonstrate empathy. Help others feel that they are understood by being an active listener. Appropriate assertiveness. State your case without arousing the defenses of another person. Remember to use I statements to communicate your feelings directly. Manage emotions. Stick strictly to the facts of the complaint and communicate your feelings directly. Have a willingness to resolve. Identify barriers to avoid resolution and overcome those barriers. Avoid repeating the situation. If the complainant persists with their complaint, direct them to file their complaint with USDA's Office of Civil Rights. In no way is a sponsor to impede on a customer's right to file a civil rights complaint. Limited English proficiency. are those individuals who do not speak English as their primary language and who have a limited ability to read, speak, write, or understand English. Sponsors must take reasonable steps to assure meaningful access to information and services they provide to individuals with LEP. Reasonable steps would include an evaluation of the following action factors: the number or portion of LEP people eligible to be served or likely to be encountered by the program, the frequency with which LEP individuals come in contact with the program, the nature and importance of the program, activity or service provided by the program to people's lives, the resources that are available, and the cost to provide these services. A shortage of resources or anticipated cost to provide these services to individuals with LEP does not eliminate the requirement to do so. Sponsors must explore the most cost-effective means of delivering services and information to people with LEP. All child nutrition program information should be provided in the necessary language for all participants and their families. For example, enrollment forms, menus, brochures, and letters should be provided the necessary language for all participants and their families. Language interpreters can be helpful when dealing with someone with limited English proficiency. Children should not be used as interpreters. Volunteers may be used, but they should understand the ethics required when using an interpreter. For example, a Spanish teacher could assist a household in completing a meal application, but would need to be trained on the importance of keeping all information confidential. Racial and ethnic data is used to determine how effectively your program is reaching potentially eligible children and where outreach may be needed. All sponsors that participate in a USDA child nutrition program must have a system to collect the racial and ethnic data of program participants in accordance with FNS Instruction 113-1. This data is used to determine the state's compliance with federal civil rights laws. USDA regulations state that respect for individual dignity should guide the process and methods for collecting data on race and ethnicity. Therefore, self-identification or self-reporting is the preferred method of obtaining characteristic data. The use of visual observation and identification by a SFSP sponsor is not an appropriate method for collecting race and ethnicity data in the SFSP. The collection of this information is strictly for statistical reporting requirements and has no effect on the determination of their eligibility to receive program benefits. This data must be collected annually. This data must be maintained in a confidential file for 3 years plus the current year, and this information should be restricted to authorized sponsor personnel and other authorized state and federal personnel when requested. The requirement to end the practice of visual identification went into effect on May 17, 2021. By January 1st, 2023, program operators must have alternate means to capture the data. An alternate means of obtaining racial ethnic data is utilizing data from another source in which the respondent has self-identified race and ethnicity, such as a school database, or asking the parents and guardians of participants to voluntarily self-identify the participants' race and ethnic groups. Be sure to explain that the racial ethnic data is to ensure compliance with USDA non-discrimination requirements and will not affect the participants' eligibility for meals. FNS discourages asking a child to self-identify their race and ethnicity, as this practice may be confusing to young children. However, FNS understands that requesting information verbally may be uncomfortable for staff and for participants. Respect for individual dignity should guide the processes and methods for collecting data on race and ethnicity. Ideally, respondent self-identification should be facilitated to the greatest extent possible. State agencies and program operators may wish to consider the following to collect data. Use individual school enrollment data to obtain racial and ethnic data for individual children. SFSP sites that are able to obtain children's names and have access to school enrollment records may use them to obtain racial and ethnic data. Providing racial and ethnic data is voluntary to program participants. If a program operator is unable to collect the participants' information, their response may be marked unknown. For this reason, FNS does not expect that the number of respondents will equal the number of children at a meal service site. However, FNS does expect program operators to continue to try to capture the data. Additional resources can be found at FNS Instructions 113-1, Part 12, in addition to the previously referenced policy memos. Ethnicity is broken down into two categories: Hispanic or Latino, or non-Hispanic or non-Latino. The racial categories include American Indian or Alaska Native, Asian, Black or African American, Native Hawaiian, or other Pacific Islander, and white. A person may identify as belonging to multiple racial categories. Reasonable accommodations must be provided to participants with disabilities in the child nutrition program. Reasonable accommodations refer to ensuring that participants with a disability have physical access to programs and services such as easily accessible entrances, restrooms, etc. A sponsor is required to provide food substitutions or modifications for a student with a dietary disability. A written medical statement completed and signed by a licensed physician, advanced practice nurse with prescriptive authority, or a physician assistant is required to be on file when the request falls outside the meal pattern. Meal modifications within the meal pattern do not require a medical statement. Meal modifications outside of the meal pattern do require a medical statement provided by a licensed medical provider. A licensed medical provider includes a medical doctor, physician assistant, or a nurse practitioner. The medical statement must include information about the child's impairment in reference to how it restricts the diet, an explanation of what must be done to accommodate the disability, and the foods to be omitted along with the recommended alternatives. In the medical statement, if the medical statement does not fully explain the modification needed, the sponsor should contact the guardian for additional information. As a reminder, receipt of clarification should not delay the modified diet. Applicants and participants must be advised of their right to file a complaint, how to file a complaint, and complaint procedures. Any person who believes they have been discriminated against based on protected classes, which are national origin, race, sex, color, age, or disability, has a right to file a complaint within 180 days of the alleged discriminatory action. Complaints may be written, verbal, or observed. A complaint may also be anonymous. Anonymous complaints should be handled the same as any other complaint. If the complaint is verbal and the person alleging discrimination is not inclined to put the allegation in writing, the person to whom the complaint was made to must write up the complaint on behalf of the complainant. The first step is to document the complaint and make an effort to obtain the following information: name, address, and phone number of complaint, specific name and location of entity delivering the benefit or service, the nature of the incident, action, or method of administration that led the complainant to feel discriminated against, the basis on which the complaint feels discrimination exists, the names, titles, business addresses, and phone numbers of persons who may have knowledge of the discriminatory action, and the date or dates during which the alleged discriminatory actions occurred, or if continuing, the duration of such actions. All complaints should then be forwarded directly to USDA. The second step for civil rights complaints is to contact USDA. All verbal or written complaints must be forwarded to the Civil Rights Division of USDA Food and Nutrition Services within 3 days of receiving a complaint. The third step in civil rights complaint is to maintain documentation. All civil rights documentation should be kept at a central location and should be maintained for 3 years plus the current year. Here is an example of the discrimination complaint form. It can be accessed at the hyperlink on this slide. All staff must be trained on civil rights and this civil rights complaint form. The complaint form must be available at all sites participating in the child nutrition programs. When an individual wants to report and file a discrimination complaint, child nutrition staff should have as little involvement as possible with the complaint process. Staff should allow individuals to file their own complaint with as little involvement as possible. Okay. A few civil rights reminders to keep in mind are: USDA Regional Office is responsible for the review of the state agencies. The state agencies are responsible for the review of the sponsoring organization. State agencies must report any significant findings to USDA. Sponsors must receive a pre-approval visit to ensure compliance with civil rights before receiving federal funds. Compliance is assessed through the administrative review. If non-compliance is indicated, a corrective action plan must be implemented to achieve voluntary compliance within 60 days. The corrective action plan should describe the agency's actions to be taken to resolve the non-compliance determination. If the corrective action is not achieved within 60 days, suspension of assistance or termination may result. Here is your checklist for civil rights compliance. Civil rights, written policy, and complaint log should be kept. Train all staff and volunteers annually. All staff should know CNP civil rights policy. prominently display the And Justice for All poster, collect and record racial ethnic data, keep all records for 3 years plus the current year, maintain civil rights compliant procedures and forms, place non-discrimination statement on all printed materials mentioning child nutrition programs. As a reminder, district policies regarding civil rights complaints should specify how civil rights compliance is handled for the CNP separate from other programs. Provided here is a list of useful resources to ensure your program is in compliance with USDA civil rights requirements. If you have any questions, please feel free to contact us at 225-342-9661 or at Child Nutrition Programs at la.gov. Thank you for your time and attending this presentation. Have a good afternoon.